ser sentimentos egoístas ou apenas uma motivação infeliz de querer ser melhor do que o outro. Por isso que ele fala no versículo 4, não tenha cada um em vista o que é propriamente seu, senão cada qual o que é do outro. Segundo o texto, nós devemos agir assim, porque nós agimos por humildade. Nós devemos amar o próximo, servir as pessoas, como se eles fossem superiores a nós. E aqui é importante que fique bem claro que o texto não está falando que o outro é superior a nós. Nós devemos ter essa perspectiva como se, de fato, o outro fosse superior, mas não é. Nós sabemos que, biblicamente, Deus fez o homem, fez a mulher, todos são iguais perante Deus, não há ninguém que tenha um mérito maior do que o outro. Então, nós devemos considerar o outro superior, sem que, de fato, esse seja. Mas a pergunta que nós podemos levantar é, por que eu devo agir assim? Por que eu não devo apenas pensar em mim, em uma competição, em uma concorrência, só pensar nos meus benefícios e devo pensar no próximo? O texto continua o seu argumento, e o argumento é basicamente o seguinte: nós devemos agir assim, porque Cristo agiu assim. E eu quero ler alguns versículos da continuação do texto, que diz o seguinte: tende em vós o mesmo sentimento que houve também em Cristo Jesus, pois ele, subsistindo em forma de Deus, não julgou como usurpação ser igual a Deus, antes a si mesmo se esvaziou, assumindo a forma de servo, tornando-se em semelhança de homens, e reconhecido em figura humana, assim se humilhou, tornando-se obediente até a morte, e a morte de cruz. O que vemos aqui, que o argumento presente no texto é, nós devemos ser humildes, considerar os outros melhores do que nós mesmos, porque o próprio Filho de Deus, Cristo, ele agiu dessa maneira. A humildade de Cristo se baseia, primeiro, no fato dele, sendo Deus, eterno com o Pai, ele decidiu se esvaziar da sua natureza, então se limitar a um tempo, a um espaço. Imagina aquele que é o Criador de todas as coisas, ser posto nas mãos de uma mulher, tendo que ser feita a higiene daquele corpo, daquele bebê, e aquele é o Criador de todas as coisas, que está ali nos braços de Maria, e crescendo em graça, mas também no fato dele ter morrido na cruz do Calvário. Isso mostra que, ao morrer na cruz, ao morrer uma morte substitutiva, ele levou em consideração não apenas os seus interesses, mas o interesse de uma humanidade que estava em queda e que precisava de um Redentor. Mas também pelo fato dele ter vindo até nós, e não nascendo em um palácio, em um lugar cheio de pompa, com uma cama confortável. Não, ele nasceu logo e foi colocado em uma estrebaria, e em nenhum momento ele se tornou um homem rico. Na verdade, ele era até mesmo, sofreu chacota, porque o seu reino não era um reino de aparência que as pessoas viam e que viam riqueza nele. Ele se dizia um rei, mas que não tinha dinheiro, que não tinha ouro. Ele se esvaziou, assumindo, então, uma forma de servo. Então, o ponto aqui é, se nós olhamos para Cristo, vemos que aquilo que traz maior beleza para a nossa vida é o fato de parecermos com aquilo que ele é, considerarmos o outro melhor do que nós e servirmos uns aos outros. Queridos, é importante que fique claro uma coisa: se nós somos doutores, temos autoridade, poder na sociedade, nós não deixaremos de ter esse poder porque servimos ao próximo ou porque tratamos os outros de forma amável e graciosa. Nós continuaremos tendo essa autoridade, mas o que trará ainda mais beleza e firmeza para aquilo que nós temos é justamente a nossa condição de sermos tratáveis, cuidarmos bem do próximo. No final das contas, o nosso grande legado não é se as pessoas lembram da gente como pessoas influentes e poderosas na sociedade. As pessoas lembrarão de momentos em que fomos graciosas com elas, em que agimos com misericórdia, em que pudemos auxiliar alguém que estava em um dia difícil. Esse tipo de atitude, tal como Cristo fez, cuidando dos mais necessitados, cuidando daqueles que padeciam, é isso que de fato traz beleza para aquilo que nós somos. É a graça de Deus na pessoa de Cristo. Então, eu quero concluir com, basicamente, duas lições ou duas aplicações que a gente pode trazer para nós. É que a motivação, aquilo que leva a gente a agir, não deve ser o egoísmo ou o benefício próprio. Nós devemos deixar esse tipo de competição, de atitude um pouco mais egoísta, né? Vamos deixar para as empresas, que elas lutam ali para ficarem firmes no mercado, vamos deixar para os atletas nas Olimpíadas. O atleta ele não pode ser muito solidário, ele tem que ser firme para poder ganhar do seu oponente, né? Apesar de vermos exemplos maravilhosos de solidariedade nas Olimpíadas. E vamos deixar também para as crianças, que muitas vezes não têm uma capacidade de discernir a sua atitude. Mas nós, como adultos e pessoas que conhecem a realidade de quem é Cristo e daquilo que ele fez, nós podemos nos esvaziar de nós mesmos e agirmos com graça. E também, se em primeiro lugar eu falei a respeito da nossa atitude, eu quero falar também a respeito do nosso sentimento. Nós agimos de certa forma, com arrogância, com competição, com deslealdade, muitas vezes, é porque o nosso coração é que está corrompido. Nós nos sentimos, muitas vezes, melhores do que os outros, ou queremos que o outro veja que nós somos melhores. Mas aquilo que vai mostrar a sua nobreza, tenha certeza, nunca é o fato de você pisar em alguém, nunca é o fato de você gritar com alguém, mas o fato de você agir com graça, amor, misericórdia, porque o próprio Filho de Deus, sendo glorioso e poderoso, ele agiu assim, com graça, acolhendo o pior tipo de gente que tinha na sua época, que as pessoas diziam, olha, não posso ouvir esse mestre, porque ele recebe todo tipo de gente, as pessoas piores da sociedade ele recebe. Sim, nós recebemos a todos, com graça, amor, misericórdia, palavra de encorajamento. Então, deixemos as disputas para as empresas, para os atletas, quanto a nós que possamos agir com graça, amor e misericórdia. Quero fazer uma breve oração, pedindo a Deus que abençoe o nosso evento. Senhor, nós te agradecemos por essa manhã de trabalho, que o Senhor abençoe a todos, professores, cada um dos amigos que estão aqui acompanhando, seja pela transmissão ou aqui de maneira presencial. Que o Senhor nos dê, Pai, um coração, um sentimento semelhante ao seu, que sendo o Deus da glória, se tornou homem e serviu ao próximo, agiu com graça, acolheu as pessoas, que possamos agir assim, Senhor, a semelhança do Senhor. Nós oramos assim em nome do Senhor Jesus Cristo. Amém. Amém. Deus.
Muito obrigado, reverendo Bruno. Palavras sempre importantes, e para motivar ainda mais o nosso evento. Como o senhor disse, a concorrência está nas empresas, está nos atletas, e na sociedade a gente tem que ter esse espírito, né, cristão. E quando as empresas, tão como os atletas, não agem em conformidade com a lei, com a regra, tem que ter o direito, né? Então nós temos o direito da concorrência que acaba regulando quando as empresas desviam do seu caminho também para tentar vencer de forma desleal, anticompetitiva. Muito obrigado, reverendo Bruno. Well, dear all, before starting, I would like also to thank Professora Juliana and University of São Paulo Law School from Ribeirão Preto for kindly sharing Professor Magali with us. It is an initiative from Professora Juliana and from USP Ribeirão Preto for bringing Professor Magali from Scotland. And as Professora Juliana said, today in São Paulo, we have a little bit of Scottish weather here in São Paulo. Yes, just for you don't miss your home.
Thank you.
Okay, and even the name of our university, Mackenzie, right? It's very Scottish. Okay, and I'd like also to congratulate our fellows that are following us from a YouTube channel from Mackenzie, and the students from Professora Juliana and USP Ribeirão Preto, and Mackenzie students that are in the countryside because the classes didn't start yet, only next week. So, Professora Juliana, I will leave the floor to you, so you can share some comments before send the floor to Professor Magali. And I would like also to thank Professor Marco Schiavo from Mackenzie for attending this conference with us. And I know he has some questions to Professor Magali later on. But Professor Juliana, the floor is yours.
So thank you, Professor Vicente. For me, it's a great pleasure to be here again. Um, we are doing together, I think, special work related to dissemination of antitrust here in Brazil. This is a topic that for us is very important, not only because our researchers are based on this, but also because we still have this problem here in Brazil that we have only few universities presenting this topic and this subject in some way, not in a specific way, but in some way to the students. And to have Professor Nagli here is something very special for us, because she's doing a great job, not only inside the Academic Society for Competition Law, but also as a professor. I think that the papers that she is, and she shared for us some of them, they are very touching some points that here in Brazil we are still discussing. So this is why I think it's very interesting, because even based on the experience that we have in UK and EU, the topics are still very important topics for us. So having her here with Vicente, and also with the support of the University of São Paulo and here the University of Mackenzie, I think shows to everyone that it's very important to work together, right? I think that together we can do much more than alone. And following this spirit, as I said yesterday, I'm not a kind of monopolist professor. That's why I'm glad to know, and also to have this opportunity to show to Nagli a little bit more about our institutions, especially the institutions that are really focusing on spread the knowledge related to competition law. So thank you, Nagli, to come, because I know it was a very long journey, right? I hope now you feel more comfortable with this beautiful weather that we have today that remembers your home. But I really would like to thank you for coming, to have your enthusiasm here with us. And also, I think it's a huge opportunity for us to listen to you. And of course, the questions we touch in some points that for Brazilians are very important, but the floor is yours.
Thank you. Thank you to everyone. I honestly am really, really happy to be in Brazil. I have been looking at what goes on in Brazil, and for a while I've been really fascinated. I think there's a lot of thought and research and debate going on here that we could actually learn from. So I'm happy to be here, but mostly what I would like is for you to, tell me after I give my presentation, tell me how you see things in Brazil, whether any of this makes sense. So this is really why I'm here. So I'd like to learn from you as well. So what I want to talk about today is a development in the European Union, which I have my doubts about. I have my questions about. And so I'm going to touch upon this development illustrated by a particular case, and I'd like to hear your thoughts about it. So as a little bit of context, in the European Union, under abuse of dominance, so abuse of market power, we can have both exclusionary problems and exploitative problems. So we care about, competitors being excluded from the market, but in theory, we also care about the situation where a powerful company uses its power to harm its trading partners, to harm its customers, to harm its suppliers. I say in theory because since 2003, we haven't really done much of these cases in the EU. And there are many reasons for that. Some of it has been this idea that we wanted to be more modern and rationalize the way we do competition law. But the social and economic, background context in Europe has changed. We are in I would say, a weaker position than we used to be economically, but particularly politically and societally. And there's a feeling with digital markets, companies like Facebook and Google, but not just there, other industries as well, that people are suffering, that small businesses are suffering, that consumers and citizens are suffering, and that something should be done. And so the case I want to talk about today is a case that really came down to trying to bring back this idea of exploitation, how we should stop powerful companies from hurting their customers, their trading partners. And it's a case that a lot of people are excited about, but I am a little bit worried about. And so that's why I want to talk about it today. I don't know if there is a clicker, but otherwise, next slide. Perfect. Okay, great. Okay. The context is that of exploitation, but also of data protection. I don't know how much you know about data protection in Europe, but for a while now we have had the General Data Protection Regulation, the GDPR, which has been both a success and a disaster at the same time. It's been, I think, a success because it's been a signaling that in Europe we care about the privacy of everyone in ordinary life. I remember when the GDPR came in force, suddenly my email was full of alerts from all the companies that I ever had anything to do with, telling me, we have data on you, do you consent on us still using it? So it was hundreds upon hundreds of emails. But in a way, it made me feel, okay, you know, something is being done. And oh my God, how I didn't even know this company had so much information on me. The downside has been that for a lot of small companies and small organizations, the GDPR has been quite a burdensome system. So you have to jump through a lot of hoops. You have to do a lot of administration to comply with the GDPR. And there is a feeling that big companies really haven't lived up to what this data protection system was supposed to create. So that if you have power, you can still find ways around not protecting people's privacy. And what usually happens, at least in Europe, I don't know if this is the same here, but what usually happens is that when we feel like one regulator has failed, we try to use the competition authority to fix the problem. And this is what has happened here. So I'm going to talk about, thank you, the German Facebook case, which was a case at a German level, which ended up all the way at the EU level about trying to use competition law to intervene where we believe the GDPR isn't working so well or isn't being complied with as well. I have to do a little bit of boring background before I can go about the case, which is I have to explain to you how the EU's competition law system works. Because when we talk about EU competition law, we most of the time talk about what happens at the EU level, where our enforcer is the European Commission. But in actual fact, we have 27 other enforcers, because at national level, every member state of the EU not only can enforce EU competition law, but has an obligation to enforce EU competition law. And cases will only really arrive at EU level, either because it's a big case that involves multiple countries, so the European Commission steps in, it has an impact on the whole of the EU, and the European Commission thinks it's a big case, or because a national court doesn't know what to do and asks the EU court a question. We call that a preliminary reference. But it's in a way a bit of a complicated system, because in addition to the EU's competition law, every country in Europe has its own version of competition law. Before the early 2000s, there were fewer of them, but also really all the EU competition law cases happened centrally within the European Commission, but in the early 2000s, we decentralized so that the member states could be involved. And there was a long debate about whether a national country could have rules, national rules that were different from the EU rules. And as we always do in Europe, we came up with a really bad compromise. And the really bad compromise, and this is my opinion that it's bad, I'm sure the European Commission would say it's wonderful, but I think it's a bad compromise because it's unclear. So in principle, you as a member state, as a country of the EU, when a anti-competitive conduct can have an impact on multiple European countries, you have to follow EU competition law, and your national law cannot deviate from EU competition law. So in theory, it should always be the same, right? So German competition law should be the same as EU competition law, but there are exceptions. When it comes to abuse of dominance, you can, as a country of the European Union, have stricter rules. You can have stricter abuse of dominance rules, but there are loads of rules trying to find a way for this to not conflict with EU competition law. But in principle, you can have stricter rules, but they are the national rules. That means that if you enforce the EU rules, you still have to follow the EU principles. But if you enforce the national rules, you can be stricter. You see how it becomes complicated. And this was a problem in the German Facebook case, because the Germans use German competition law, not EU competition law, to come up with a case that I think at EU level would not have happened like this. But now everybody's excited about this case as a standard for future cases. But I think we have not actually answered the question whether this is something that we could even do at EU level. So, next slide, please. Okay, thank you. So, what happened in the German case? The German case is a cool case, right? I think it's a very interesting case. I don't know how many here still use Facebook, whether it's very uncool to use Facebook, but even if you don't use Facebook, maybe you use Instagram. So this still applies to you, okay? What happened? Well, the German Competition Authority decided to look at the data protection regulation. So it tried to bring a case against Facebook, which combined competition law and the data protection regulation. But remember, German competition law, not EU competition law. And they looked at Facebook and they said, we think you are breaching data protection principles. Because not only do you collect information on people using Facebook when they are on Facebook, but you also collect information on them anywhere else on the internet. I don't know how many of you are aware that when you are on a non-Facebook website, they often have relationships like third-party cookies, and they collect information on you even when you're not on Facebook, and they combine it with your Facebook data. And so the German Competition Authority was worried about this and said this violates data protection principles because we as consumers, we didn't consent to this. We might be aware that our data is being collected when we're on the Facebook platform, but I think most consumers aren't that aware that the data is also being sent to Facebook when they are shopping, I don't know, for a new dress, okay? And so, in principle, if there really is a problem of consent, if consumers haven't consented, haven't agreed to this data collection, this is a data protection problem, and the Data Protection Authority should intervene and protect us. But in Europe, the responsible data protection authority is the Irish, and the Irish Data Protection Authority, a lot of people say, doesn't really do much. And so the Germans said, maybe there is a different way to stop this happening. Maybe this is an abuse of dominant position. Okay. So basically, breaching GDPR, breaching data protection, equals abuse of dominance. Under German law, this in a way was a continuation. It went further, but it was a continuation of something that already existed under German competition law, which is that terms, conditions for using a service can be considered exploitative if a company has market power and the terms that they impose in a way break another law. Right? So if you break, for example, consumer protection or unfair trading conditions, those terms are considered exploitative because in essence, they are unreasonable because they break the law. So this is really what happens here. The German Competition Authority says, you have market power, Facebook, you are dominant in social networking, your data protection violates the GDPR, therefore you are abusing your dominance. There immediately becomes a problem at national level because the German court says, no, you cannot do this. It is not enough to say that data protection is broken to immediately assume that there is a competition law violation. These are two different rules. And the national German court says other companies also have these terms and conditions. Companies without market power also have third-party cookies on other websites. So it is not that Facebook is able to break the GDPR because it has power. Everybody breaks the GDPR. So it's not a competition problem, it's just a bad data protection problem. But the German Competition Authority said no. What matters is that breaking the GDPR is worse when you've got market power because the effects on consumers are worse, the effects on competition are worse, your power increases because you can have so much data. It's a very long story, but it goes to a German court that says that the Competition Authority shouldn't have done what they did. Then it goes to the Supreme Court in Germany. And the Supreme Court in Germany says, we agree with the Competition Authority, but we think they got it wrong. We think there is a competition problem. But it's not a competition problem because the GDPR was broken. It's a competition problem because it's an excessive price. Basically, Facebook is collecting too much information. The price to use the service is too high. Okay. All the time, this is a problem of national law. But when the case finally makes it back to the national court is so confused, so unsure on what to do, that they ask the Court of Justice a question. So yes, the case goes to the Court of Justice. And the Court of Justice in the European Union, when a national court, so a German court, has a question about how to interpret the law, what to do, that has an EU dimension, they can ask the highest court of the European Union to give an answer on what the law means. Everybody gets excited in Europe. This is it. This is the case. We are finally going to have a clear answer on whether a breach of data protection, a breach of privacy rules is also an abuse of dominance. I was not excited at all, because I thought that what we really needed to know is whether the German Competition Authority was breaking EU principles, right? Because they were bringing a case under national principles, which really affected the whole of the European Union. In good European fashion, we didn't get an answer to anything at all. We got the Court of Justice saying, well, data protection is interesting for competition law. It's a relevant factor to consider, but it's only one of multiple factors, okay? The breach of a non-competition law cannot automatically also mean there is an abuse of dominance. But in a way, the Court of Justice left it open. It never told us whether or not we can say that breaching another law is enough to find an abuse of dominance. Nonetheless, the whole world is excited about the idea of data protection and competition law combinations, right? So it didn't stop other cases from popping up. I don't know how many of you have heard of this, but in France, the French Competition Authority said, you know, in Germany, breaking one law that wasn't a competition law, data protection, was enough to say there was a breach of competition law. Well, we are saying that breaking copyright is enough to find an abuse of dominance. The doors have been opened in other countries to do this now. And the European Union didn't say whether or not this was allowed. So we're in a very odd situation now where it isn't clear whether you can do this. Now, fundamentally speaking, I think we can all agree that data and privacy is a part of competition, right? It's a very important element. But I am not sure whether we are in a good situation now where any breach of any law, if you have market power, can be considered to be an abuse of dominance. The European Union is in a position where they're trying to bring more cases on exploitation, but there is no clarity on where we stand. And the reason why I think it's important is because these things tend to set precedents across the European Union. They tend to also go to the US and feed in there in national courts. And I am wondering what kind of signaling it gives. And I don't know what the answer is. I don't know if we should say that breaching data protection is bad enough that, it's an abuse of dominance. But I am wondering about it. And I am particularly wondering whether you have some kind of similar situation here. How do you look at exploitation? How do you look at the relationship between privacy and competition law? So yes, I'm not sure the point at which we stand, but I would be curious to hear your thoughts particularly. And the last thing that I think is interesting here is that maybe it's irrelevant now. Because in the EU, we have a thing called the Digital Markets Act. So we're regulating the big tech companies. And one of the obligations on companies like Facebook now is to change the way they process data. Facebook, to comply with the Digital Markets Act, offered to do a pay or consent model. I don't know if you know what that means, but in practice, it means that if you're in the European Union, you can choose to either consent to full data processing or you pay a monthly subscription fee to not have your data collected as much. The European Union said it's not good enough. The price is too high and there is still too much data being collected. But that leads to an existential question for companies like Facebook. How much data are they allowed to collect, which is what they need to monetize their service? And if they're not allowed to collect our information, how much are we willing to pay a month to have a Facebook or an Instagram or a WhatsApp that doesn't collect our information? So only a couple of weeks ago, the European Commission, the European Union said, you're not doing the right thing with your monthly subscription fee in the European Union. But I would be really interested. If you here in Brazil were told WhatsApp is entirely free, Facebook is entirely free, Instagram is entirely free, but we will fully collect your information, will you choose that? Or will you pay, I think, I'm trying to convert in my head, right? 14, I want to say like 1,000 real, is that right? For not having your data collected, what would you do? So I'd be curious. In the European Union, it didn't seem like many people started paying. I was willing to pay because I felt like we had to prove a point, but I think I was one of the only people. So would you pay? So where does that leave us? How can we deal with these big companies, with the fear we have about what they do with our data, if we're not willing to pay? Do we just tell them they have to shut down? Would we be happy about that? So that's a question, I guess, to the room. But yeah, that's me.
Thank you so much, Professor Magali. May I jump in, Professor Juliana, Professor Marco, with some comments? Before my comments, Professor Juliana, it's also important to highlight that is an initiative of a Escola Brazil chapter to promote the advocacy of competition. So it's important to have you here, Professor Magali, to widespread the culture of competition in Brazil. Your presentation was very interesting, and the case that you mentioned. And I remembered another case. It was Facebook WhatsApp back to 2000, I don't know, 15, maybe 16. And in my opinion, the decision of the DG Comp at the time was wrong. Okay, I remember they approved they give the clearance of the merger, and saying that there is no competition issues here. Maybe there is a data issue, and data issues will be regulated by the data commission, data general officer. I don't remember exactly the name, but there is a board to take care of that. And just like the merger, to have the merger approved, Facebook mentioned that we will not collect the data provided from WhatsApp. We will keep the different things, Facebook and WhatsApp. But just after the clearance of the merger, Facebook started to use the data provided from WhatsApp, Bundeskartellamt, and Autorità Garante della Concorrenza e del Mercato, the Italian Competition Authority. They initiate 2 investigations, and in both situations, Facebook was convicted. Regarding the Italian decision, there, the competition authority, they apply competition and what you say here in Brazil, consumer, and also, consumer law. And the law that the competition authority applied in Italy was a consumer law to convict Facebook. And in Brazil, and Juliana, Professor Juliana can describe better than anyone here, we had the same problem, and Facebook, WhatsApp, had several meetings with CADE, with the Senacom, it's the Consumer Secretariat, and the data, if I'm not wrong, I think at the time we already had the data protector officer here in Brazil, and with the Ministério Público Federal also, Professor Juliana, as the federal prosecutors, yes. So, and then we had an agreement that Facebook made a deal with the authorities in Brazil to have, because at the time I remember, Professor Magali, I have a WhatsApp, almost Brazilians, all the Brazilians have WhatsApp, and you received a message. If you want to keep using your WhatsApp account, you allow Facebook to have your data. And I think this is what called the attention of the authorities here in Brazil. So some comments, just to mention that I think the problem didn't start now with this case. It started back when the EU approved the deal WhatsApp Facebook. Another comment, and then I will leave the floor for the important authorities here, is that in Brazil, we don't have very clear the concept of exploitation by the competition authority. And in my opinion, this is something that we should review, because it's clear. Even CADE explained that, there is exploitative when you're talking about abuse of dominance, but it's difficult, CADE, to apply the concept of exploitation to convict some company with dominance in the market. Just a few comments. Thank you very much. And please, Professor Juliana, Professor Marco, then you can leave the floor for the audience also.
Thank you, Professor Vicente. I think you're touching in many, aspects that they are still in an ongoing discussion here in Brazil. But I would like also to listen to Professor that was making several notes here, as I can see. So I think it's a great opportunity to have your thoughts and then go back to Magali again.
Thank you so much. For me, it's a privilege to be here. I admire so much Professor Juliana and also Professor Vicente. It's an honor. And I want also to thank Magali for having the opportunity for the conversation. Congratulations for the paper and very insightful work. I have some notes here, two quick questions and one general comment. So I had the opportunity also to, read the paper in the Journal of European Competition. I guess it's the similar proposed in your presentation. And also congratulations on the paper, very nice, very insightful as well. So my first question would be, it's kind of a rhetorical and reflexive question, because I usually take a more sociological approach towards, the economic law and antitrust law. So wouldn't it be the case of framing, the judgment of the European Court of Justice, instead of the idea of missed opportunity, to the idea of the benefit of the silence? So the point here is the idea of missed opportunity that you discuss in the paper can be understood as, a protection and a safeguard for the European Court of Justice not getting involved in a bigger political problem and also regulatory issue that is happening in Europe. So it was a strategic movement on the court. Of course, as from the dogmatic perspective, it's for sure it's very frustrating. But regarding the political environment, it was a strategic move for the European Court of Justice. So instead of using the idea of missed opportunity, wouldn't be something interesting to perhaps reflect more on the idea of the benefit of the silence in this case? So this would be more the reflexive question. And even now after the case, right? I think more than 1 year now, right? I would like to know if this makes sense, the idea of the benefit of silence. The second question, and I'm sorry, I'm not getting into the in the center of the paper, that's the discussion of EU application versus the national legislation. But I think that one important issue behind this case is, trying to establish a path for a collaborative relationship between the authorities and try to avoid unnecessary and conflicting overlaps. Like data protection, who has the final word regarding, saying the impact of the the breach of data and the competition consequences of that. So, do you believe that anything has substantively changed after this case? And I think you choose an interesting framework of trying to frame on the substantive part and also to the procedural part. I guess in the procedural aspect, you are very unsatisfied, but perhaps in the substantive part, things changed in EU after this case, specifically on the national court. So you mentioned the French case, right? And this brings me on my third comment, because I think this case had some impact here in Brazil. So I think you're probably aware, right, that IDEC, a non-governmental organization for protection of consumer rights, reported to CADE, and that our antitrust authority, SENACON, the Secretariat for Protection of Consumer Rights, and ANPD, the Data Protection Officer, about abusive practice by Meta, and actually it mentioned the European case. ANPD suspended the Meta privacy policy. CADE started investigation of Meta practices, and even now, I think last week, the Federal Judiciary in Brazil is also now deciding on a public civil action, we call ACP, Ação Civil Pública, that was brought by the prosecutor office here in Brazil, seeking damages from WhatsApp and Meta here for non-compliance of our LGPD, our GDPR, and also targeting the state. NPD mentioned that they are handling the situation with lack of transparency and inefficiency. So there's also now a dispute between authorities, which brings some problems in order to try to produce more stability regarding the protection of personal data and also antitrust. So my point here is basically there is a constellation of authorities involved in the problem in Brazil, and I think in some manners also in EU. But there is also a great deal of uncertainty about the roles and limits which end up facilitating the action of companies like Meta, and so wouldn't be the case, for a more strict regulation, or perhaps, how to manage and engage a more collaborative relationship between the authorities. There are so many overlaps even between the authorities that is there's some difficulty in order to try to decide and find a final solution. And this also, for me, evoke the idea of the difficulties in the beginning of the 19th in Brazil in order to regulate the sectors, because we had also several disputes between authorities, CADE and Bacen, our central bank. So I guess perhaps one possible way is trying to have more strict regulations regarding what are the limits of each authority. So I would like to hear you also on this point. What's the impact of the regulation, the importance of regulation in situations of what you mentioned here in this case. So just 3 brief general comments.
Thank you.
There's a lot of food for thought. I'm going to start with the point about the Facebook WhatsApp. I mean, that was a disaster. I think the European Commission was so naive, right? So naive. First of all, this actually also goes to the point you made. They didn't want to step into really the area of another authority, which is ironic considering that now we are in a situation where that's exactly what the competition authorities are doing. They're stepping into what data protection authorities should be doing, because so early on in the process, we allowed Facebook to buy WhatsApp because we believed the data protection authority would intervene. But it's not just that. They were naive because Facebook comes to you and says, we're buying WhatsApp, but don't worry, we don't care about the data. Like, honestly, just looking back at it now, it's insane, but I also think it was insane at the time, right? I don't think it's like hindsight, suddenly we understand better. There was a lot of naivety there. I mean, and Facebook's been punished a few times now for lying, for misleading the European Commission, but, you know, it's a drop in the ocean. You pay a few fines, but really you've got the data that you wanted. And so I think we are in a problematic situation because I actually think the merger decision, it wasn't about data protection. You could have just said that a combination of data assets was increasing market power. End of story, right? Block the merger or make it very conditional. And you wouldn't even have to bring in data protection. Now we're in a situation where you have to bring in data protection because the assets have been combined, and we're not talking about the power that it creates, but about the harm to privacy. So it's a different theory of harm. It's not about accumulating market power and excluding competitors. It's about hurting your consumers directly. And this is exploitation. So you mentioned that here it's not fully developed, but in Europe, it's not fully developed either. We are in a very uncomfortable position with exploitative abuses, because we now have new cases being brought. So recently there was the Apple Music streaming decision in the European Union, which was based on exploitation. And it was one of the first times in years that we had an exploitative case. And what is the legal test there? That it's unreasonable terms and conditions that aren't necessary for a legitimate interest. That's not a very good legal test, right? The distinction between what is a competition problem versus what is a consumer protection problem isn't clear when it comes to exploitation. So I'm telling you, you cannot look to Europe because Europe doesn't know what to do with it. We're all in a very bad position where I think we all instinctively feel that powerful companies might be hurting their customers, but we don't have a good legal test, a legal framework to deal with it. So maybe Kari would be better at figuring it out and then telling us, because we don't know how to deal with it. It's not going to stop us from trying to deal with it. But yeah, so exploitative cases aren't great in Europe either. Benefit of the silence. I guess you could frame it that way, but I think it is, how do I put this nicely? When you are the Court of Justice of the European Union, you have a duty to make sure you are the highest court. You have a duty to make sure that the law is clear. And they didn't, right? I don't think there is a benefit of silence here. I think they, to be fair, they did try to do a few things, but they were in an unfortunate position where the questions they were being asked by the national court weren't the best questions. They could have, because in Europe, the court in the EU answers the questions that the national court asks them. But they have the right to add more questions to it. The court decided not to do that. For whatever reason, I don't know, I wasn't in the mind of the judges. And I think that was a mistake, because if you leave things vague, you open the door. And if you open the door, then all the 27 countries of the EU will step through. They will take it as an opportunity to do something, which I like. I like that about Europe. It means that you can have like experimentation and then eventually we can choose the best approach. But experimentation in Europe is all we see now, right? We've got digital markets regulation. We've got 27 different competition laws in member states. We've got the European Commission bringing decisions. Where is the coherence? Where is the clarity? And it's bad, I think, for legal certainty for the companies, but it's also bad for us as consumers, as citizens. What exactly are our rights? What exactly is it that we can expect? And honestly, I think we're in an existential crisis, right? I think we have all these tools that we're trying to use all in different ways to deal with these big companies. But I don't know if we're actually clear on what is the future that we envisage that would be a better future. Because if you don't know what the better future is, then it's very difficult to get there. And this is, I think, what the problem is, right? So maybe the benefit of the silence here, to use your wording, is that the court didn't want to be the one to say what the future should be, which I agree with. That's a political question. But it also didn't give any real legal guidance on what can be done to get anywhere. And that's a problem. But I think it's a problem. Because I guess I'm a pure legal academic. I like, some framework and consistency and coherence in our decision making. I think that would be nice. But you're right, that's one thing they did do, is talk about collaboration between data protection authorities and competition authorities, which is also an odd, it's an odd part of the judgment, because they're saying that there should be a duty of sincere cooperation. This is something we love to say in Europe. We should sincerely cooperate with each other. But it left the door open for saying that if the data protection authority hasn't done anything, the competition authority could do something if nothing has happened yet, but they do need to inform the data protection authority. There is an attempt at bringing some kind of framework for collaboration there, but it's not very robust, which I don't think the court could do, because that would be legislating, right? But I don't know if it really helps. So I think a dispute between authorities could be a problem, unless they all just decide to let the competition authority do whatever it wants to do. And so I'm really interested to hear that there are disputes between authorities here, because fundamentally, normally, you say a particular authority is in charge of a particular type of problem, but this is not how digital markets work. There is no one problem that fits in one box, right? Data protection, competition, consumer protection, they are all one and the same problem. So it's artificial to try to put them in different boxes. So it's inevitable for there to be disputes, I think, which is why I've said this last time I talked, but I think maybe in this kind of situation, competition authority shouldn't be involved, data protection authority shouldn't be involved. We need a regulator that is dedicated to this sector and this sector alone. A sectoral regulator, so that we don't have the disputes between authorities. And the Digital Markets Act in Europe is kind of that, but not really. I'm not that impressed with what it looks like, but it was a good start, I guess. So I don't know if that answers. Yeah, okay.
Magali, you brought a very interesting point here again, because we have a discussion in Brazil underway. It's a Bill of Rights about to regulate the digital platforms. And when it started, the initial idea was to have a regulator, but it was not a specific regulator. It was the telecommunication authority to regulate this market. And more recently, CADE understood that CADE is the proper authority to regulate the digital markets. And there's a debate underway in Brazil. Just to mention that.
Magali, just based on your last words here, and also the comments from Professor Vicente. I was just thinking that maybe here in Brazil, we're going to face a problem that is a constant problem, because it's really common in Brazil to have one specific issue that is regulated by a specific regulator, and then a competition regulator, and then the data protection regulator. We have multiple regulators, and besides the regulators, we also have, just like this case you mentioned related to WhatsApp. Why do we have the federal prosecutors? Because we have the commission inside, the whole board that takes care of competition and consumer protection. So they also can, start some investigation. And we also have another problem, is that our judiciary, and generally we don't have, judges that they are very comfortable to deal with issues related to regulation in general, not only. Then you can imagine if you're talking about something very specific, it's even becoming more difficult for them to, face juridical and then prepare a decision that can, have this holistic view related to the subject. So I think this is something that maybe you can just share for us, because for Brazilians, it's pretty clear that we will always have this kind of uncertainty related to some subjects, because we have these multiple regulators, and also because we have also a judiciary that is not very comfortable to deal with some topics. But as we have this imagination that I'm not sure if it's something like we are dreaming on, or if it's true enough, we don't know. How do you deal with this? Because you considering that in EU we have multiple jurisdictions. So even though we don't have several regulators, we have different people and different systems that need to be coordinated. And I think that maybe this is something that you can share for us, and then we can learn from it. And also, I think there is another topic that Professor Vicente just mentioned here, not only related to the case, but also related to the regulators and the ongoing bill. Here in Brazil, we have this fantasy about bills will solve all the problems, and it's not true. So we have several bills all the time. We are always discussing a new bill. It's something amazing. And this is another point that raised it, that some people will start to say, oh, maybe we need a new regulator. And of course, we have several problems related, we can see now, because the data protection regulator is now starting to show some movements that in the beginning was impossible, because they had no money, no budget, no people. So they created, but they needed time, to start this work, and the expectations were really high for them. So we are just trying to repeat it with a new regulator. I'm not sure it's the best way to do it, but the fact is that then I would like to hear your perspective, the UK and EU perspective. Here in Brazil, this is a very political, sensitive subject. There is an environment, a favorable environment, political environment that just put these subjects, highlight this topic, and that's why we are giving so much attention for it. So maybe you can just, share a little bit, then we can have the whole picture, at least based on your experience in EU, UK. We are not talking about US, right? But then I think we can have these reflections and think about our situation here in Brazil, and maybe try to help them, like we like to do, like Professor Vicente, the academia, we are always trying to help when everybody is very involved with these topics and start to think that we can do everything.
Okay, so no pressure there. First of all, the European Union and the United Kingdom. So I'm originally, well, I still am an EU citizen, but I live in the United Kingdom. I work in the United Kingdom, and it's really interesting to me because the United Kingdom is trying to, well, has adopted now a law, a bill to regulate digital markets, and it was slower than the European Union, but it has some significant differences to the EU version, but we don't know yet what it's going to look like in enforcement. And both in the EU and in the UK, despite the differences, it is in fact the same authority that deals with competition that is dealing with digital markets regulation, which I understand because I think in terms of the resources, the manpower, the knowledge, the expertise of dealing with these companies, it makes sense because these people already have experience with these companies. But I do have my doubts about whether this is the best approach. But it is, I think, a logical approach. The UK wants to do slightly differently from the EU. They want to have a more, how do you say it, more negotiation-based system where they, instead of immediately being clear on what the actual obligations are on the companies like Facebook and Google and Microsoft and Amazon, they will set out big principles and then negotiate codes of conduct and negotiate what that would look like in practice, which I'm interested to see how that will work out. There might be advantages to that. But so I love the UK, and if anyone from the UK is listening, this is not a slight, but the UK's economic power here is minimal, I think, because ultimately, and maybe I'll be wrong, ultimately, I think the default approach of the big companies will be the one for their biggest consumer group. And the European Union is the biggest consumer group. Why would you have a fragmented approach? Why would you have a different approach for the United Kingdom as for the EU? We're literally next to each other, and we communicate with each other all the time. So it might not be such a great idea to have a completely different approach just for the few people in the UK. So the point I'm trying to make is, I think all these questions are interesting. Having all these bills, having all these regulators, but what is your power in enforcing it? I think that is the far more important question. What is your clout? What is your bargaining position with these companies? If you massively depend on them and your consumers and your citizens depend on them, how much are you going to be willing to push back? This is a problem we already face in the EU with the adoption of artificial intelligence. Facebook was threatening not to bring a particular artificial intelligence service to the EU. And I thought, yeah, great, I don't want it, right? But a lot of people in the EU are saying, oh, but we want the best artificial intelligence. So maybe we shouldn't push too hard. So this is existentially, this is the crisis, right? So I don't have advice on what to do in Brazil, except that maybe this is about globally agreeing on an approach so that we actually have some counter power against these companies. All of us coming up with different bills is not going to solve anything, is it? Like if Brazil does something different from the European Union, the UK does something different from the European Union, and the US does nothing because currently they do nothing, is there any point? So that's the first. And then cooperation in Europe, for the most part, is actually pretty decent. Because I think we share an idea that what matters is to keep the market integrated and common and whole. Things start going wrong when we have countries or regulators that politically want to be different and they want to no longer be part of a common European project. But I don't think that's really about the resources and how we have created our authorities. I think it's a spirit, right? It's a philosophy of we're all working towards the same goal of having a common integrated system. And I think it's because it might seem far away, but for us, the spirit of the world wars is still quite fresh. So I don't, there is a lot of procedural solutions for how regulators should cooperate together. There are some that I'm working on a paper on where I think how we should divide the line between different authorities. But ultimately, all of this is me just, intellectually having fun, because I think the political will to cooperate is far more important than any kind of procedures and rules you put in place. So I guess if the one message is here being in Brazil might be that I think we should probably sit together and come up with a common approach to regulating these companies. Otherwise, I don't think we're gonna solve the problem. Yeah.
Thank you, Professor Margali. I would like to know if someone would like here to get this opportunity to ask some questions to Professor Margali. Okay, you have two.
Ladies first. No?
Hi, everybody. I'm Angela. I study in Mackenzie University. I haven't graduated yet, but I'm really interested about competition law. And I join you in your opinion that we should find a universal and a global solution for that, because Instagram, Facebook, and WhatsApp is all a global thing, everyone is adapted to that. So, but how would we do that? That's my question. And who should start it? I don't know. How is the path?
Okay, my name is Vinicius. I am a doctorate student here in Mackenzie. The competition law is not my field of research. I am researching data protection, and therefore my interest for this event, for which I really thank the professors, the organization. It's a great opportunity to learn from you. And how can I say? I see that the uncertainty of the concepts is leading to very dangerous doubts concerning the competition law, and therefore it may benefit the biggest organizations and turn like we say in Brazil, it is when you shoot your own foot. I don't know the expression in English. And I see many things like this regarding the data protection. It's the really same thing. We impose a lot of rights for people, individual rights, but by exercising these rights, we just benefit the big organizations because we allow it. We give them our consent. So when the professor says that there must be a collaboration in an international level, should how can we do that with more precise expressions, more precise rights, and in different with different economies working together? How can we approach this? It's maybe a very hard mission, but what would be the first steps for it?
Hi, Professor. Many thanks for being here with us. My name is Vinicius. I'm a student here in Mackenzie. Professor Vicente has been orienting me. And I have some points and noted some things while you were speaking. And from my point of view, the digital markets and the digital platforms can also offer advantages to competition and consumers. Once they are compliant with the law, of course. For instance, they provide more information about products, facilitates the easier research about prices, for example. And my question is, Do you think digital market regulations such as DMA or the new UK law could make the business of the business operation of platforms unfeasible? Thank you very much. Thank you, Professor Vicente, Juliana, and Marco.
Thank you. So how and who? Look, this is a difficult question, and I am worried about, in a way, being, what's the word for it? Eurocentric. Because there has been, I mean, I travel a lot, and in some countries, what they do is they wait for a European project, whether it's a law or a decision, and then they use that as leverage to impose similar conditions on the companies in their own country. And I think this is what has happened with data protection, and I think to some extent this is what's happening with digital regulation. And I think the European Union loves that, right? So I don't know, there's a book by Professor Bradford, which basically says the US creates the companies and the innovation. It also speaks about China, and then the EU sets the standard of regulation and protection. And we are so proud of that. But that means that whatever is being set as a standard is a standard from a European consumer perspective, and we are not the same consumers. I do not need WhatsApp in my life. I can do without. I do not need online payments. I can do without. I am very aware that I am from a very privileged economic situation where I could live without these companies. But I don't think that's true, for example, for Thailand. I don't think they can live without these companies. And so for us to come in and say, this is how we should regulate this and these standards, that's a big thing. But I think de facto, that is what is happening. I think the European Union is setting the standard for digital regulation and taking the leads. What I wish is that there was more interaction where there was more space for other countries to come in and say, okay, but do you know what the effects are of the regulation you are setting and the standards you are setting? The only thing that we see so far is US pushback. But pushback is not really what I think from the US particularly we need. What I think is we need to have more dialogue, right? So if the European Union wants to be the regulator for the world, there is definitely a democratic legitimacy problem there, right? Because we're regulating for citizens that are not our citizens. So we should have more of a conversation. And I think that's on Europe. And I think because it's difficult to do that because you're constantly busy doing things. And there are networks, there's like the International Competition Network where these discussions are being had. But that's technical discussions. It's not openly public, democratic discussions. So I think this is, to me, the next step is to have these conversations about what is the impact of digital regulation that is being done in Europe. But again, that's a very Eurocentric view. I know what we have, and I think we should have a debate about it. If other countries came up with other pieces of regulation and they were better, I would actually think that would be quite nice to do it the other way around. But that is not currently happening. So yeah, that's the first thing. But yes, I'm very uncomfortable with Europe being the regulator for the world because I don't think it's a legitimate thing to do. But I think it's really the only situation we have. And you're saying the uncertainty benefits the biggest organizations. I think this was true for data protection. I am not sure if it's true right now for digital regulation because I feel almost sorry. Almost, not entirely, almost sorry for Google, Amazon, Facebook, Microsoft, because they are spending all their time in Brussels. They are there all the time in workshops, in debates, sending people, discussing, debating. Facebook offers to create a subscription model and says, look, that complies with what you told us to do. And the European Union says, it's not good enough. So, okay, but you know, what alternative should they do? So I'm starting to feel sorry for them. So I think here the biggest organizations are not benefiting. Maybe they will in the future when the dust is settled and the rules are clear. But because the rules are not clear, it is a moving target, right? The rules are so vague that if Google offers a solution, the European Union can say, we don't like it so much. Come up with something better. And there is no clarity in the law of when that stops. So this is different from data protection. There is no like one principle of consent, for example. So are we making the business models of these companies unfeasible to some extent? Yes. Yes, absolutely. I think we are, not all the time, but one of the things that when I wrote my PhD, in one of the chapters I wrote that we have, and I think this is changing now, but we had accepted that of all the business models that could have arisen on the internet, advertising-based business models were the default. It didn't have to be that way. It was a group of like maybe 10 investors in the US that made it that way, right? They invested money in companies like Facebook, and they said you need to start making money, and advertising was the fastest way to do that. And so we got the advertising funded business models. It didn't have to be that way. We could have been more creative, but we let really like not so creative people take the lead. So maybe this model becomes less feasible. Maybe we're opening the door for different business models. But ultimately, that means that in the process, we are going to lose certain of these companies that might be bringing benefits in a particular way, and new problems might arise that we don't yet know will arise. But again, that's a luxury problem, I think, for places like Europe, because in a way, I think there is a willingness to sacrifice some of these business models on the path to what we believe is a better future. And I will repeat that I don't think that works for the whole world, right? Again, if I didn't have WhatsApp tomorrow, I wouldn't be able to communicate with you, Juliana. That would make me very sad. But sure, I'll go back to text message, right? I don't use it for payments or anything else. I saw advertising on Uber for the first time when I was here. It blew my mind. Like, I'm already paying for a car. Why do I have to pay for ads, honestly? So, you know, I feel like a lot of these businesses are far more ingrained in other countries than they are in Europe. So I'm willing to sacrifice it, but I don't think this is true for everywhere else. So it's not really an answer. Yes, it's an answer to say, yes, I think we are making some of these business models unfeasible. I, as a European citizen, am not so worried, but I absolutely think globally that should be worrying if we don't come up with alternatives. I don't know if you noticed, but years ago, the European Union tried to create its own search engine. It was the worst search engine ever. It was so bad. And now there's other attempts. There's a attempt to create a internet infrastructure, a European internet infrastructure that would be the baseline for the internet in Europe. It's a really cool idea. I don't know if it's going to work. And I don't think we can sacrifice these companies until we've got alternatives, but this is what we are doing. So yeah, I'm making more problems than solutions, I'm sorry. But yeah.
Magali, maybe you already answered my question, but once I read I think it was in the New York Times, I can't say that I agree, okay, but it was written there. US creates, China copiates, and EU regulates. Yes. Maybe EU is missing the focus on how to regulate, because when we check the big digital platform, the super platforms, we can't find a EU digital platform. Just one. Yeah, but just
look, we have to have something.
Yeah, it's Spotify. Yeah, but when you go in the list, I think Spotify. It's, I don't know, maybe the 10th, the 20th, the 5th. We have US and China basically. Yeah, maybe EU is missing the focus how to regulate, and is not leaving space for EU digital platform to rise.
Oh yeah, absolutely. I mean, there is currently European politicians that are trying to say we should reduce the amount of competition enforcement so we can have big giants, which as a competition academic makes me feel so uncomfortable, but I understand why they're saying this. But I don't think the solution is less regulation. I think the solution is more investment. Let's be clear. We we have a standard of living in Europe which comes with massive costs. And I very much enjoy that standard of living. But, you know, if you have more expensive workforces, if setting up businesses comes with high costs to start, if there aren't many big banks financing companies, you are not going to get the innovation that will drive things forward. But this is a political question about what future we want, right? So one of the, in the research center that I am deputy director of, we now have a working group about, is all innovation good innovation? And I think this is fundamentally the question we should be asking, right? What innovation do we want? Do we just want everything to come from anywhere and then we will regulate later the problems? Or do we want to have targeted investment in particular types of innovation? And I think we are missing the ball in Europe. We're so used to having been the powerhouse of the world that for the last 100 years, we've not tried so hard anymore. And we are being bypassed by the US and China. Absolutely. But regulation and competition has no role to play, I don't think. It's about finance. It's about labor relations. It's about subsidies. China massively subsidizes its countries. The US has started to massively subsidize its companies. The EU has very strict rules on subsidization because we think it's anti-competitive to overly subsidize. So what do? Those are the things we need to change if we want more innovation. But I don't know if all European citizens want more innovation. Maybe we will be left behind and the rest of the world will innovate more. But maybe that is a political choice. I don't know. And political winds are changing in Europe. But yeah, I think the New York Times is right. That is exactly the situation we are in. Yeah.
Okay, Professor Juliana, should we close the session?
Yes, I know it's taking a little bit longer, and Magali is always very open to all our comments and questions. I would like first to thank you, Vicente, Mackenzie, for hosting this part of this week that we are dedicating to competition law. As we have here a rising star, Professor Magali, that is always a great friend, besides being a great professor and researcher. And of course, I think we have here taking and also paying attention to the comments from Magali, Professor Vicente, and you all. I think we know that this is a topic that we are going to follow for the next months and probably years, because as you touch, Magali, I think we still have here issues to develop that are also related to the environment that we have here, especially talking about Latin America. She was really surprised about the fact that we are using WhatsApp all the time, and yes, we do it, right? And based on the fact that when we had one decision that the judge decided to cut WhatsApp, and everybody was, you can't imagine what happened that day. It was just like a little war inside our country, right? So the effect was even bigger than we could imagine.
WhatsApp in Brazil, Magali, is not as a social media. WhatsApp is for business also in Brazil. It's very common to change information with lawyers and clients using WhatsApp.
But then how do you get away from people? Like they're constantly on your phone.
We work 24 hours a day.
Okay, that's
They shouldn't have our WhatsApp here. Yeah, can you imagine at the end of the year? Oh, my grades. Oh, come on, what happened?
absolutely not. I love my students, but they will not get my WhatsApp or phone number.
Yeah, I think we are very sweet in Brazil, because in fact, we usually gave our number to our students. So it's super crazy, right? We know that. Maybe this can be the next topic for our conference.
Work-life balance, Julia.
Yes, yes. But it's amazing to have you here, especially because you are doing a great job about a scholar. And I think only to go ahead, and then, of course, everybody wants to have lunch in the right time. But I think it will be good for everyone, especially because we are going to share this not only in the University of São Paulo webpage, but also Mackenzie about Moscow Scholar, in a scholar, yes. So I think, yes. So thinking about a scholar and knowing that a scholar is waiting much more engagement from Brazilians. And we just had this very nice, amazing conference in Germany. I can tell you, I was really surprised by the fact that the professors, because I was thinking, I cannot say that, because I studied piano, but I can't. It's impossible. They're professionals. So it was really beautiful. Everything was great, but I could hear that they are expecting more people from Latin America. And based on what we have here, that Brazil, we have much more scholars than outside. We cannot compare Brazil with Argentina or Chile in number of researchers. So I think it's a great opportunity to you to share a little bit the changes from the last year, the future. I think this is something that may make some of you here in presence or online, pay attention a little bit more about this whole community. I think this is something that we must do it, and maybe you also can give some tips about the researchers that they are ongoing and doing some research to go abroad. But this is something that I think we must, create spaces for them to go abroad.
You can announce the 2025
I can, yeah.
Chicago conference.
Yeah, so ASCOLA is the Academic Society for Competition Law. I am now one of the vice presidents, and I love the society because once a year, there's now 2 events, but there's one in-person event where all the scholars from the world can come together, present what is going on. So this year we also had 2 different panels where there were academics saying what was happening in their region and also enforcers saying what was happening in their region, including Juliana was on the panel. We also had South Africa and Germany and US and France. And I really want more engagement. It's one of the main things that drives me to be part of the executive of ASCOLA. Is I think, obviously I love hearing from Europe because it's what I do, but I think there's a lot going on in the world that we are blind to, we don't understand, and having academics come and present to us and say what they are working on and what is happening in their regions, I think is incredibly important. So I would love you to come to Chicago, which, so end of June, we will go to Chicago. There's also a newsletter for ASCOLA that I run. So if you want to sign up, you will get all the information in September about the next conference. I am well aware these conferences are expensive to go to. There is no sign-up fee. There's a membership fee, which is 40 to 80 euros, depending on whether you're junior or not. That's for the whole year. There's no conference fee, but the travel is expensive. If you are a junior scholar, you can apply for some financial aid. But yes, it's expensive, and I think that's why one of the problems with the conference. So another call is maybe the Brazilian universities should host it one year, I'm just saying. And then you can all stay here and join us. And on coming abroad, if you're a student and you want to study, I'm just going to do a pitch, and you're thinking about going to the United States, don't come to the United Kingdom. It is far cheaper. Our programs are excellent. The weather isn't great, but depending on where you go in the United States, the weather is bad as well. So I don't think a lot of Brazilians consider the United Kingdom as much. Maybe London. I was teaching in the London School of Economics. There were some Brazilians there. But come to Scotland, right? We do a lot of competition law, and we're a fraction of the US price. And we have very nice food. I know people don't believe it, but we have very nice food. Although you've been feeding me Brazilian food, so I feel like I can't really say this anymore, but yeah.
So thank you.
Okay, just to close the session, thank you very much. And thanks, Mackenzie, for all the support. And a special thanks to you, Magali, for being here with us today. Thank you so much.
Nossa, não consegui descansar até agora, sabia?